So the names I recognize Emily's name on there. We won't make this hopefully too boring. That'll only be about 20 minutes. And also feel free, if you have a question, just stop me and just please let me know what the question might be. That'd be great. That would work out really good. I see Sharon Miller, so that's cool. Can you allow me to share? If I can get it on here. No, that's not it. I knew it might have an issue with it. Let's see.
We see your screen, but is it not the right screen?
No, let me, can you see that?
No.
No. Let me see. Um, Here we go. Here we go. Let's see. You can see that now?
Yes.
Cool. All right. So, all right. So let me tell you a little bit about the preliminary title report. Thanks again for having me. So a preliminary report is dated formal report that sets out in detail the conditions under which a policy of title insurance would be issued on a particular parcel of land. The report reflects the matters which would be shown as exceptions in a policy of title insurance so that the parties to the transaction will be aware of any of those matters of record that may need to be cleared prior to the closing of the transaction. This usually would happen between us and escrow. This report is issued before the actual title policy gets sent out, hence the name of a preliminary title report. So when you get a report from us, or a few of the title companies out there will have a very similar look. Number one, you know, we are sister companies of Lawyers, Fidelity, Chicago Tycor are going to have a very, very, very similar look. So this would be the first page that you would get. And basically on here, the way the title companies have this, you might have experienced this already, is that we have a custom to view a title look. I don't know if you can see my mouse where it's at. So if you were to click on that, you would get this page. And so I thought that I was going to perhaps talk about this page last, which would be a summary of the actual report. But in reality, we're going to go through it first real quick. So between title and escrow, or should I say the title representative, usually, you know, I will look at a prelim and let you know the items that are of, you know, of interest. Because obviously a title report has many items. As you can see on this particular one, we have 22 items. And, you know, we will show everything and everything that's of record, okay? So on the summary report, it acts really good for you guys. When you click on that, I'm going to go back to it. When you click on that custom view title look, and some of the other title companies might have a similar name. I believe they use the same system. So when you click on that, it's going to give you this page, and we put it we will highlight certain things. So in yellow, basically just needs your attention, you know, like property taxes. But if we put it in red, it means it really needs your attention, because it could become an issue towards the end of the transaction. So item 21, we have a deed of trust. We have it in yellow, so you know that we're going to be paying off a deed of trust. But item 22 is a notice of independent solar energy. So that means you got solar, you have a lease that you have to deal with, and that could be problematic. Actually, on this report, which was done just not too long ago, that solar system actually is problematic because it's run by Sunrun. So between title and escrow, Sunrun went bankrupt. So between us, we would figure out who took over that account. And so therefore we could deal with getting an actual release. Okay. So getting to the actual title report, you can see this page, right? So on here, we show lawyer's title, so our address. On the right, we have the title order number. For a reference, ourselves and escrow will use primarily our order number, or you can also do the address between the two. If you're dealing with escrow would love it if you just give them their escrow number, number one, to identify the actual file. So in this case, we show the owner, we show the real estate agent here on the left. On the right would be Connections Escrow. In this case, it's a pre-open, so don't have that. And the paragraph right here basically states the lawyer's title is prepared to issue the policy, and points out the fact that there could be exceptions and exclusions to the actual policy, okay? So on the second page here, we will show what type of policy this particular property is going to get. We state on number one that it's a fee. So a fee, here's a good question here, because I get this question a lot. An agent will ask me if is this property a single family or is it a condominium? And so a lot of times they'll ask that because they have a freestanding building and they think it should be a single family as opposed to a condo. You can go right to your preliminary title report. We're going to state it here. If it says fee, single family, if we show condo, it is a condo. Even if it looks and feels like a single family home, it is a condo. Item 2, we will show you who the vested owner is. If there are questions on as far as who actually owns it, everything in blue is basically a link that you can click on and actually be able to see the actual vesting deed, whether it's a grant deed or a quitclaim deed. A lot of times I believe for agents, the item 2 is important because sometimes you may not have the exact vesting that you are accustomed to. And the reason for that could be that they've recorded a deed, changing the vesting, adding a person, taking a person out, but that particular deed is not insured. If it's not insured, the title companies are going to show you basically the vesting that is insured, and then they will make a note to the fact that there's been a change, and we just want to double check that actually did take place. And so that's where we put a lot of work on escrow, because they'll have to check on that to make sure that it's correct. Item 3 also it basically describes the property. So there you have the parcel number that is the number that's given by the assessor, and the title companies are basically insuring that parcel number, which would give you the legal description. In this particular home, what we have is not a simple lot and block, as a simple subdivision. This is more meets and bounds. So it's not just a lot with a subdivision, which usually would have only taken like 4 lines to describe the property. In this case, it's meets and bounds, and it just goes on beginning at the southwesterly side, yada, 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 okay? So it makes it a little bit harder, but this is what the title companies are insuring, and not necessarily the actual address. I hate to tell you, but the address does almost means nothing, because you can change the address and make it to be pretty much what you needs to be, want to be, because I've had that in the past, and you can actually change the addresses and get help from the assessor if you feel that the address should be a number off or what have you. You know, that can be done, and some of you might have had an experience with that in the past. So going to item, now we're going into the exceptions to the policy, okay? So we will show the taxes. In this case, the first installment has been paid. We show it paid right there. The second installment is still open, but it doesn't become delinquent until after April 10th. I had a scare. I was on Facebook 2 days ago, and somebody had posted on there that just kind of a reminder, but they said the wrong thing. They said that the taxes were due in February, like February 2nd, but delinquent April 1st. And I was like, oh my gosh, no, did I miss it? Did I miss the date? And then realized that no, you still have until the 10th, so you don't have to pay an additional 10%. So like in this case, if you were late by 1 day, you're paying an additional $376. This particular property, when you look on here, you can tell whether it's owner, pretty much if it's owner occupied or not, because in this case, we have a homeowner's exemption. So they'll take $7,000 off your taxes because it is owner occupied. Under the taxes, if this property had defaulted taxes or supplemental taxes, which would mean that a property was either new construction or had just changed vesting not that long ago, you would have supplemental taxes, and we would show those supplemental taxes right on here under item 2, 3, something like that. We would show that. In this report, we're going to show a lot of water easements, in this case, showing water rights. And a lot of times we also end up having, things recorded that are having to do with the developer. Unfortunately, the title companies have to show everything that gets recorded against the property. And a lot of this stuff is just a lot of fluff, and that actually would pertain back to when, not in this particular property, but like if you've got newer subdivisions, whether it's Mira Mesa, Scripps Ranch, whatever, you'll end up having a lot of documents that actually were contracts that they do with the developer, between the developer and the city. So don't be alarmed when you see a lot of that stuff, you know. The title companies have to show it because it's of record, but does it really concern the new buyer? I would say no. So anyway, so items 5, 6, they all talking about water and stuff like that. So if there are easements, you know, like in this case on 7, St. Louis Ray Municipal Water District has an easement over the land. If the easement has a description, like I'm going to show you here, if the easement has a description, we obviously will show it. We actually show the plotted easements. You get to see exactly where everything is. But a lot of times, whether it's drainage easements or certain types of easements, they are not disclosed of record. So they don't show you, excuse me, they don't show you exactly where the easement is. And that can happen quite often. So we have that. In this case, like if a property has a road maintenance agreement, we would show that. There are properties sometimes that have, what they have is I encountered this a lot up like in Escondido. They'll have a road, no road maintenance agreement on it, but it's still a private road. Even if they try to grant it to the city would have to accept it. A lot of times they don't. So it's between the owners that have to use that particular road when it comes time to maintain it. And then there is a law in place that would help the owners facilitate what they would have to do to get that road up to par, so those owners could travel it. So that's a road maintenance agreement. Item 10 here, we talk about the CC&Rs, Declaration of Covenants. No, excuse me. On this one, it's not that. It's for improvements. But also, what I find that is important is we're going to get to the fact that if there are CC&Rs recorded on the property, I believe that that's something that the buyer should definitely take some time to kind of look over it and read them in case there are any surprises. 13 shows that as a SDG&E utility easement. And in this case, that particular easement says the location of the above easement is not disclosed of record. So you can't, it's just more of a visual thing than an actual something that's going to be plotted. So let's see, let me try to mention a couple other things of interest. 16 is those CC&Rs, and CC&Rs can be modified all the time. So you have quite a few different documents that got recorded to modify the CC&R, so that takes place. If there are any agreements, that sort of thing, you know, we will put everything that's against the property obviously gets be put on there. Item 21, this is the deed of trust that's actually against the property. If when you're looking at this and the actual page that we showed you here showing the summary of it, we showed the deed of trust, you know. If we only show you one deed of trust, but you know that there are two, contact us. You contact us, you contact escrow. So we can deal with that. Or actually, usually what happens is the other way around. We might show you two deeds of trust, but in reality, there's only one. And usually what happens there is that one of those deeds of trust had been released, but unfortunately, the actual release has never taken place, has never been recorded. And so then we have to deal with that. We have to figure out, sometimes we just simply take them out. Sometimes it's not as easy to take them out. It just depends what that loan is, okay? So 21 is the deed of trust in this particular report. That's of interest. That's something that gets paid off through escrow. If the loan had been sold or there was a substitution of trustee or anything like that, we will post all that information on there. And it's not a real concern. Escrow will deal with the actual assignment of any new beneficial interest, that's for sure. But otherwise, it's just not a big deal. And so, like we had mentioned on the summary page, we put it in red, the notice of independence of solar energy. So that's an issue on the report. So we show you that Sunrun is the company. Sunrun went bankrupt. So you have to, we'd have to deal with that to get a release. So, and if escrows are not familiar with the fact that Sunrun has been, went under, we, as the title company, will assist in giving them the proper information to be able to get a release from whoever took it over. Let's see. So let me see if I could mention a couple other things that could, obviously on the deed of trust, if it was in default, we would show that the deed of trust is in default, you know, if there's a notice of trustee sale, obviously we'll tell you that. Obviously you can talk to us as far as trying to figure out what's going on and what needs to be done. Some other items that we would show on a report, you know, would be like an abstract of judgment. So if that happens, you know, obviously we would show. What's very important is that to come up with like an abstract of judgment, those liens are against the individual's name. So it's very important that you get the sellers to do their statement of identification. So to fill out that form, they get it through escrow, they get it through title, fill that out there so we can clear the name, just in case you have names that are very similar. So if that happens, you know, I think that the title companies are more apt to put a lien on, let's say, an abstract of judgment or a tax lien, anything like that, even if we don't know that it's our 100% our party. But then when we get the statement of identification, we can figure it out who the lien is actually against, okay? So if we have to, you know, remove something, that's not a big deal. So obviously IRS liens, we mentioned unsecured tax liens also. Any type of pending litigation we're going to show. There is also one that you don't see very often, and you see it more like in the 4S Ranch, the payment of transfer required. If there's a payment of transfer required, which is usually about a 1% fee, we will show that's of record, and we would show that on the report. So you would know that that seller would be paying a 1% transfer fee to actually convey the property. So basically, that is the preliminary title report. And like I said, between escrow and us, the title, we're going to go through it, and we're going to let you know if there are any red flags that you need to be aware of. So like this particular client right away, I told her, we got to deal with the independent solar company, and it's a company that went bankrupt. So there you go. I hope you guys might have a question or two. I'd love to answer it. But that is a preliminary title report, and it's worth going through it, and I try to point out what really can make a difference, and that's the vesting. Make sure that it is your people. And then the items that we put in red, obviously you want to check that out to make sure that we're going to take care of that, and that there are no surprises. The surprise part is tough. We don't want that, but we have to deal with it. So, anybody have any questions? I mean, I know we've seen preliminary title reports forever and ever. Go ahead, Sharon.
Somewhat related, you touched on uninsured transfers.
Right.
Is there a way, and I'm thinking a lot of times, I believe perhaps those have occurred when people have decided to transfer title into a trust, and the attorney, maybe they have attorney draw up the deed, it gets recorded, but those, I think, oftentimes are uninsured. Is there a way to get them insured without a large expense?
I would say that that's definitely something that you don't have to worry about. Once that deed is recorded and it's put into the trust, you don't really need insurance on that. We would cover them. So in other words, they got insurance when they got the property. They put it into a trust. They're still insured if something was to come up. So there's no need to actually put insurance on that. Most of the time, and you know what? As you say that, I see it quite often where an attorney will draw up a trust and nobody takes the time to actually change the vesting. That's important, or they'll put it on the consumer to take care of getting it actually recorded. If you ever have anything like that, you need questions answered on that, you can call me. I don't mind talking to the client and explaining to them, what needs to happen. But that would be the only thing. So I would say no, definitely you do not need to spend money on that. I've actually had an attorney call me, someone that's trying to make some money, and it's exactly the situation that you're talking about, having title insurance because now there's a new entity. And I'm saying, no, I'm not doing that because they don't need it. I'm not charging you another $500 to put the property under the fact that it's insured. I mean, the guy was just trying to make a buck on people that don't have actually the document, like you said, insured. It's not necessary. You should not have to do that at all.
Is it important to notify your title company? This question came to me yesterday from a client. Is it important to notify the title company? Is it necessary when you do change vesting into a trust so that the title company is aware of it?
It is not necessary, Sharon. You do not have to do that at all because we will continue the insurance even though you put it into the trust, and that is of record. So no, you definitely don't have to contact the title company. It's a done deal. You're fine. It's all good. And as a matter of fact, as we deal like property managers, real estate agents, when they deal with their clients, a lot of times if the vesting is a single person, that person needs a little bit of advice. And what I mean by that is make them aware. You have the property as a single person. If you were to pass, now that property has to go into probate. So and that still happens a lot. I just have one who called me. Oh yeah, my good buddy, John Frasca. He's got one that the individual died and it's just as a single person. So now we don't even know if this individual has heirs. Now they need an attorney. They need to go into court and try to figure out who's going to get the property. And if there is nobody, it eventually would end up with the state, and that would be awful. But yeah, everybody needs to make sure that they have a vesting, whether it's in joint tenancy or a trust, of course, is the best thing to do. But when you own it as yourself, you should put if you have any beneficiaries down the line, you should get a trust. Because you could get a trust inexpensively for just an individual, let's say. So yeah, but you don't have to worry about notifying the title company or anything like that. You're still insured and you have it under a trust.
Thank
Yep.
you very much.
Yeah, you're welcome. If anybody has questions on things that need to be recorded, a client calls you, what should I do? I give clients advice all the time. I don't mind doing it. Some people shy away from it. I don't see where the liability is on me. I'm trying to help you out. So, because what I would say is that a lot of times when they're trying to change the vesting, a client might say, talk to my client, and I'll gladly do it because I want them to understand what could happen if they change the vesting, meaning that there could be a tax implication, liability, and therefore I will let them know you need to be aware of that the taxes can be reassessed. And if need be, I say, you got to talk to your tax accountant because you could have a tax implication here. I got one right now, which is really bad. It will get solved. We had an individual that brought someone into the property because they wanted to make sure if something happened to that individual could stay in the property forever with a reverse mortgage. They give the property to him. They didn't do it correctly. And so that individual died within a couple of months. Guess what the tax assessor did? They automatically reassessed the property. Someone that was already had 100%, but because they deeded away 50%, now the assessor is taxing him, trying to get the property taxes reassessed for that. So we're helping these people fight all that out to try to, there's a proper word that escapes me right now, but basically that this transfer never happened. They can go backwards. There's a word for it. And I'm sure that we will be successful figuring that out so that that individual does not have a new tax burden, And Jordan Marks tries to be helpful, down at the assessor. So he's good, and he takes pride in what he does down there. So he's helped me out a few times. Any other questions? I'd love to answer them. Well, thank you very much. I appreciate it. If a question comes up or whatever, you're free to call me, send me an email. That would be fine. And we can go from there.
Thank you, Marcos.
All right. Thanks, you guys. Good to see you.
Bye, everybody.
Thank you, Sarah. Okay, take care. Bye-bye.